हाय हेलो वेलकम टू प्रोइंग सीरीज। चलो अब नेगोशिएबल इंस्ट्रूमेंट एक्ट के केसेस देख लेते हैं। ओके, लेट्स सी दिस। ए ड्रॉज बिल्स ऑफ एक्सचेंज पेएबल टू हिमसेल्फ ऑन एक्स, ठीक है, हु एक्सेप्ट्स द बिल विदाउट कंसिडरेशन। ओह, विदाउट कंसिडरेशन। देखो, बिल्स जनरली विदाउट कंसिडरेशन होता तो नहीं है, लेकिन यहाँ पे अगर विदाउट कंसिडरेशन है जस्ट टू अकोमोडेट, इसका मतलब ये क्वेश्चन अकोमोडेशन बिल का है। Accommodation bill. Okay, so remember, a bill without a consideration could be accommodation bill. So then A transfers the bill to P for a good consideration. State the rights of A and P, and would your answer be different if A transferred the bill to B after the maturity? Okay, so ये accommodation bills के बारे में पूछा गया है. Okay, let's see that. So in the given case of accommodation bill, the accommodation bill drawer does not give any consideration to the drawee. बराबर, आप वही समझा रहे हो. Thus, the relationship between the drawer and the drawee is not that of creditor and debtor. Yeah, it is not a creditor or debtor relationship proper. It is drawn with an object to provide financial help either to the drawer or both drawer and the drawee. So एक तरह से ये दोनों के लिए भी हेल्पफुल हो सकता है या एक पर्सन के लिए भी हेल्पफुल हो सकता है, but it is basically drawn just to accommodate the other party, not with a consideration. The party accommodating is called accommodation party, and the party accommodated is called accommodated party. So it's an accommodating party and an accommodated party. Okay, let's try and understand further. तो अब यहाँ पे आगे क्या लिखेंगे और हम उसके फीचर्स बताते हैं. Following are the salient features of accommodation bills. The following are the salient features of the accommodation bills. What are the features? फिर आप लिखोगे. First, no obligation of drawee towards the drawer. There's no obligation. Then आप लिख सकते हो drawee is liable to the holder in value even if he knows that it is accommodation bill. So if a holder acquires for a valuable, then the liability of drawee comes into picture. It can be negotiated even after its maturity, and the holder can become a holder in due course also. So even after maturity, it can be negotiated. Yes, that's the uniqueness. Non-presentment for the payment does not discharge the drawer, because the drawer himself know that he is accommodating bill, तो उसकी खुद की personal liability है, तो it does not discharge the drawer. Failure to give notice of dishonor does not discharge the liability of the prior parties also. तो ये accommodation bills के कुछ uniqueness है जो आप यहाँ पे लिख सकते हो. फिर आप लिखते हो in the present case, looking at above provisions, we can conclude that X is not liable to A because A is an accommodated party. Personal liability कुछ नहीं है, बराबर. फिर आप लिखते हो but he is liable to P because P is a holder for value. Perfect, clear. And even if A transfer the instrument to P after the maturity, P will have the right against X. P will have the right against X because the accommodation bill is an exception to the rule that transferee cannot become holder in due course. So that's how P still has the liability towards X because the transferee can become a holder in due course. So if the transfer is made after the maturity of the instrument, since the transfer is after the maturity of the instrument, तो ये अपने एक्चुअली एक अकोमोडेशन बिल का क्वेश्चन ही था जिसको एक सिचुएशन में डाल के पूछ लिया. तो ठीक है, हमने अकोमोडेशन बिल के फीचर्स और उसके साथ इस सिचुएशन की एनालिसिस कर डाली. ओके, लेट्स सी दी अदर वन. दूसरे वाले में क्या हुआ था, लेट्स सी दिस. B issued a check for 1,25,000 in favor of S. Okay, B had sufficient amount in the bank account. Okay, and the check was not presented within the reasonable time to the bank for payment. Okay, आपको मालूम है check 3 months के लिए valid होता है, तो it was not present. The bank in the meantime became insolvent. Oh, the bank in the meantime became insolvent. Under the provisions of negotiable, whether S can recover the amount from B? Interesting question. The bank has become insolvent now. So यहाँ पर let's see according to section 72 of the Negotiable Instruments Act, it is the duty of the holder of check to present the check to the bank for payment before the relationship between the bank and the drawer is spoiled. ये लिखा भी हुआ that you have to present the check as soon as possible before the relationship between the bank and the drawer is spoiled. इसलिए चेक को लंबे समय तक नहीं रखते, दे आर प्रेजेंटेड एज सून एज पॉसिबल. ओके, अदरवाइज द होल्डर कैन नॉट होल्ड द ड्रॉवर लायबल इन केस ऑफ नॉन पेमेंट. ये भी लिखा हुआ है. Okay, interesting. Na? So the holder cannot hold the drawer liable in case of non-payment. According to section 74, the check is not presented by the holder for non-payment within reasonable time. Okay, and the relationship between the bank and the drawer is spoiled, or the bank refuses to make the payment. So in that case, the drawer cannot be held responsible for or even liable for dishonor. S cannot hold, be liable and cannot recover the money. इसलिए बोलते हैं always present the check within a reasonable time. And what is reasonable time? The validity of a check. So if you don't present the check within the validity period, it is beyond the reasonable time. And I would suggest present the check as soon as possible. Okay, don't even wait for 3 months. Okay, fine, unless you have a post-dated check or antedated. Okay, let's see the other one. Mr. Wise obtains fraudulently from R a cross-check, not negotiable. Fraudulently. Yeah? The transfer of the check to V, who get the check in cash from ANS Bank Limited, which is not the drawee bank. Surprising, but अच्छा खासा fraud कर लेते. R, on coming to know about the fraudulent act of Mr. Wise, sue ANS Bank for the recovery of the money. Refer with the negotiable instrument whether R will succeed in his claim. Okay, and would your answer be still the same in case Mr. Y does not transfer the check and gets the check in cash from ABS Bank himself? Quite interesting question. Okay, यहाँ पे section 130 of negotiable instrument hit होता है. एक cross check को जब आप not negotiable hit करते हो तो कैसे वो deal होता है? Not negotiable. By the way, he has obtained fraudulently, वो भी ध्यान रखेंगे. So आंसर लिखते समय हम क्या लिख रहे हैं? हम लिख रहे हैं section 130 of the Negotiable Instrument Act. A person who is taking a check cross generally or specially, bearing in either case the words not negotiable, shall not have or shall not be able to give a better title to the check than the title the person to whom he has took. So in not negotiable, you can transfer only that title, what you have procured from the previous parties, not the otherwise. तो अगर आपका चेक नॉट नेगोशिएबल है तो आप कोई बहुत अच्छा टाइटल नहीं दे सकते. इसलिए मैं बोला फ्रॉडुलेंटली, इस वर्ड पे भी हम आ रहे हैं. In the consequence of the title of the transfer is defective, the title of the transfer is defective, the title of the transferee would be vitiated by the defect. The title of the transferee would be vitiated by the defect. The title of the transfer is defective, then the transferee title will also be affected by that defect. Okay. So if the holder has a good title, he can still transfer it with a good title. So if you get something with a good title, you can transfer with a good title. That's the simple law. Okay. But if the transferer has defective title, then the transferee is affected by such defects. अब देखो क्या एक्सप्लेन कर रहे हो कि एक तो टाइटल के वजह से अगर आपको फ्रॉडुलेंट चेक मिला है तो आपका टाइटल सही नहीं है, एंड देन यू आर एक्सप्लेनिंग दैट इफ यू हैव अ बैड टाइटल और इफ यू डू नॉट हैव अ गुड टाइटल, यू कैन नॉट ट्रांसफर अ गुड टाइटल. As simple as this. Okay, and he cannot claim the right of a holder in due course also. He cannot claim the right of a holder in due course also. That's the important point, because the title itself is defective. By proving that he has purchased the instrument in good faith and for a value. Okay, now let's see this problem in certain scenarios, because इसमें एक अच्छा खासा twist है. केस 1 यहाँ पे दिया गया है, दूसरे पार्टी को दिया, और केस 2 बोल रहा है वो खुद एनकैश करता है. So in the given problem, in both the cases, we write in both the cases, R shall succeed, because the title itself was not clear. Case 1 के हिसाब से, as Mr. Wise in the given case has obtained the check fraudulently, he had no title and could not give to the bank any title to the check or money, and the bank would be liable for the amount of check for encashment. बराबर? A person who has no title, how can he give a better title to the other person? And as a result, there is a liability which can be fixed thereon. So यहाँ पे Mr. Wise, he has given a check, but he has obtained it fraudulently. So he himself has no title. So how can he transfer a good title to the other party? He cannot. Clear? That was held in the Greater Western versus County Banking. And case 2, the answer in the second case would not change and remains the same. तो आपने ये भी बता दिया, दोनों क्वेश्चन को पुट अप करते हुए देखो कैसे केस 1 केस 2 प्रेजेंट करते हुए समझा दिया. ओके, तो ये समझाने के साथ साथ अब आपको समझ में आया कि आंसर लिखना कैसे है. अब इसके साथ हम ये देखते हैं कि नेक्स्ट क्वेश्चन को कैसे डील करेंगे. लेट्स सी दिस. Okay, let's see the question. A issues an open bearer check of 10,000 in favor of B. Okay, open bearer check. Who strike out the word bearer and put crossing on the check. The check is thereafter negotiated to C and D. When it is finally presented by D, it is returned with the remarks payment countermanded by the drawer. Stop payment. Countermanded. Okay. In response to this legal notice from D, A pleads that the check was altered after it has been issued, and therefore he is not bound to pay the check. That's alteration of check. और आपने पढ़ा है alteration of check can affect the validity of a check. Interesting. Okay. Referring negotiable instrument, whether A's argument is valid, the answer is no. See, alteration as to the date, alteration as to the name, alteration as to the figures, alteration as to the signatures, that's called material alteration. But making a check, a bearer check as a cross check is not a material alteration unless it was objected. Okay, so let's see उस तरह से हम आंसर क्या लिखेंगे. पहले प्रोविजंस डिस्कस कर लेते हैं. Sometimes check may be altered between drawing and presentations, period. Okay, so sometimes the checks are altered without authority from the other. So there is no authority from the drawer of the check, and sometimes we still may alter the check. So some alterations are material and some are not. That's what I'm saying. Material alteration, hey, yani, that's exactly what you have to identify in a check. Let's see. In Alson versus Cornwall, the material alteration was defined as alteration which changes the business effect of the instrument if used for any business purpose. So whether are we changing the entire effect of the instrument if it is used for a particular business? Any alteration which is made in the instrument which causes it to speak a different language, okay, for what it was originally intended, or what changes the legal identity of the instrument in terms in relation to the parties, is a material alteration. So if it changes the date, the name, the place, it changes the entire terms of the instrument. It changes the legal identity of the instrument. It changes the relationship between the party to the instrument. That is a material alteration. Because if it does not do that, it's just an alteration, but not a material one. So a material alteration examples are changes in the time of the payment, changes in the date, the place, or any sum payable or rate of interest or relationship between the parties. So it can be changes in that factors. Clear? And effects of material alteration under section 87. See, the material alteration of a negotiable instrument becomes void as against anyone who is a party thereto at the time of making such alteration shall be valid. Okay, if the same was made in order to carry out the common interest of the original parties. So if you make a material alteration without the consent, then it is a void transaction. Why it is void? See, अगर ये alteration नहीं हुआ होता, so it would have carried the interest of the original parties. Because of this material alteration, it is not carrying the interest of a valid instrument. It is not carrying the interest of the original parties, and that's why it becomes void. So an alteration to be valid must be under full signature of the drawer. तो वहाँ पे साइन करने का, अभी तो आरबीआई ने वो भी मना कर दिया है that you cannot sign a material altered check. Now you have to put a proper check itself. Okay. Any material alteration made by endorsee shall have the effect of discharging endorsers from all the liability to him in respect of the consideration thereof. So that's the provision of law. After discussing the material alteration part, let's go back to the present case. So present case, in this problem, the check bears two alterations when it is presented to the paying banker. The word bearer has been struck off and the check has been crossed. But both the alteration do not amount to a material alteration because na name change किया, na place change की, na date change किया, ऐसा कुछ भी change नहीं हुआ था. तो ऐसा कुछ भी चेंज नहीं हुआ था. अगर ऐसा कुछ भी चेंज नहीं हुआ था, is that a material alteration? No. तो यहाँ पे hence the liability of any including the waiver is not at all affected. So यहाँ पे the liability is not at all affected and A is liable to pay the amount of the check to the holder. So liability persists, it remains, and therefore A is liable to pay the amount to the holder in this case. ओके, तो आई होप यू गॉट द पॉइंट. आप पूरा लॉ डिस्कस कर सकते हो, पार्शली डिस्कस कर सकते हो, और फिर अपना प्रेजेंट केस का आंसर दे सकते हो. कि आइडिया ये था केस लॉ का आंसर थोड़ा बड़ा रखने का, सो दैट यू लर्न द लॉ एज वेल. ओके, फाइन. लेट्स सी द नेक्स्ट वन. N is a holder of bills of exchange made payable to the order of P. The bill of exchange contains following endorsements. First endorsement P, second endorsement Q, third endorsement R, and fourth S. N strikes out S consent. N strikes out without S consent the endorsement of Q and R. तो ये उसने strike off कर दिया. Decide with reason N is entitled to recover anything from S under the provisions of this Act. Okay, so he is the holder of the instrument N और उसने इन दोनों को strike off कर दिया. क्या इससे वो recover कर सकता है? Quite interesting one. Let's see. तो यहाँ पे endorsement and strikeouts का part आता है. तो हम आंसर में क्या लिखते हैं? The question is based on section 40 of the Negotiable Instrument Act. So if you identified with section, good. If you don't identify, don't write wrong sections. Okay. Where the holder of the negotiable instrument without the consent of the endorser destroys or impairs the endorser's remedy against the prior party, then the endorser is discharged from the liability of the holder. So अगर कल को N, who is the ultimate holder, इसको S ने पेमेंट किया, तो इसके बाद S could have recovered from R, R from Q, Q from P. लेकिन if you strike them off, then S cannot recover from the prior parties. You're destroying the entire instrument of or the course of recovery. That's exactly where this question comes in. Okay, so let's analyze the present case. N is the holder of the bills of exchange. Yes, N is the holder of bills of exchange, and it is made payable to the order of the P. That's fine. The bills of exchange contains following endorsement in favor of P, Q, R, S, and N strikes out S without S consent the endorsement of Q and R. Now, thus, if the endorsement of Q and R are struck out without the consent of S, have you obtained the consent of S or the prior party? No. So, N will not be entitled to recover anything from S, and the reason being R and S, the R is a principal debtor and S is a surety for that case. Okay, because R के बाद ही S आया, तो S को एक्चुअली R से रिकवरी कर रहा है, तो प्रिंसिपल डेटर फॉर R इज अ प्रायर होल्डर पार्टी, एंड इफ यू स्ट्राइक ऑफ हिज नेम, देन द अदर पार्टी इज आल्सो स्ट्राइक्ड ऑफ. Okay, if R is released by the holder under the section 39, S being the surety is also discharged. As simple as this. So in the given problem, the rule may be stated thus that when the holder, without the consent of the endorser, impairs the endorser's remedy against the prior party, the endorser is discharged. तो अगर आप prior parties के consent के बिना काट देते हो वो instrument को, then the liability towards the other party is also discharged. Okay, so that's a unique case of section 40, and remember it's quite good number of times पूछा गया था. Okay, now the next one is 6.1. Let's see this one. J accepted the bills of exchange and gave it to K for the purpose of getting it discounted and handing over the proceeds to J. Okay, K having failed to get discount, it returned the bill to J. J tore the bill in two pieces with the intention of cancelling it and threw the pieces in the street. Okay, K picked up the pieces and pasted the two pieces and in such a manner that the bill seems to have been folded for the safe custody. Interesting. Okay, and rather than cancelled, K put into circulation and it ultimately reaches L, who took it in good faith and for a value. Is J liable to pay? Interesting case, ne? Is J liable? He फाड़ के फेंक दिया. That's it. And what is the repercussion? The other party takes it, he pastes it so well and fold it as if ये सिर्फ संभाल के रखने के लिए दिया, and he gives it to other party gives, ultimately L के पास पहुंचा. So is the party, that is J, liable for the bill? Do you know if you do not cancel the bill properly, you have the liability? Okay, let's see this one. So as per section 120 of the negotiable, no drawer of a bill shall in a suit thereupon by the holder in due course be permitted to deny the validity of the instrument as originally drawn. See, it speaks. जिसने वो बिल बनाया है वो अपनी liability नहीं wipe off कर सकता when the bill is in the hand of holder in due course. No drawer of the bill in a suit by the holder in due course, okay, permitted to challenge the validity of the instrument when the bill is originally drawn by him, okay, and the holder in due course gets a good title to the bill. Yes, he does. So in the given case, L is a holder in due course and J is liable to pay. See, इतना सा पार्ट था, and look at the implications. Okay, ये क्लिक होना चाहिए कि सर ये पार्ट था. Okay, let's see the seventh one. P draws a bill on Q for 10,000. ठीक है, Q accepts the bill. On the maturity, bill was dishonored for non-payment. अच्छा, पैसा नहीं दिया. P files a suit against Q for payment of 10,000. Q proved that the bill was accepted for value of 7,000 and as an accommodation to the plaintiff for the balance of 3,000. तो ये साबित करता है कि बिल तो एक्चुअली 7,000 का था, 3,000 का accommodation बिल था. Referring the provision whether P would succeed in recovering the whole amount of bill. Okay, whether he will be succeeding, well, I don't think so. Let's see. यहाँ पे हम लिख रहे हैं section 44 comes into picture. So when the consideration for which the bill person has signed the promissory note or a bills of exchange or even a check consisted of money and the originally absent in the part and was originally absent in the part has subsequently failed in the part, then the sum which the holder is standing in immediate relation which the signer is entitled to receive from him is proportionally reduced. क्या बोला सर? देखो इसने बोला क्या है, इसने बोला ये है कि अगर आप एक इंस्ट्रूमेंट लेते हो, when you are taking an instrument of a promissory note, bills of exchange or a check, and then it is represented by a particular money value, but the liability to that money value is not equal to the value of the instrument. जितना उस पर लिखा है उसकी इतनी वैल्यू नहीं है. The liability of the money value is not equal to the value of the instrument. Okay, but if with the relationship with the signer of the instrument, the liability is of a lesser amount, then only that proportionately reduced amount can be recovered. ये बोला गया. So in this case, जैसे इस केस में दिया गया है कि बिल भले ही 10,000 का था, लेकिन actual intention बिल का 10,000 का नहीं था. So on the basis of the above, P would be succeeding to recover only 7,000 because signer के साथ की आपकी शेयर की भी liability कितनी थी? 7,000. 3,000 was actually an accommodation bill, not an actual bill. So 7,000 only from Q and not the whole amount of the bill because it was accepted for the value of 7,000 only. Q ने उसको सिर्फ 7,000 के लिए accept किया था. 3,000 was just to accommodate, to help him out. Okay, an accommodation bill of 3,000 and 3,000 के लिए Q cannot be. The drawee cannot be made liable in accommodation bills. You know that. Okay. So fine, this is how you have to tackle the issues and एक एक करके पढ़ने का. Okay, let's see the other one. What is question number 8 saying and what we have to write in this one? Okay, now in this question, A issued a check of 5,000 to B. B did not present the check for payment within reasonable period. The bank fails. However, when the check was ought to be presented to the bank, there was sufficient funds to make the payment. Now B demands payment from me. Can A be made liable? It is a similar question जो अभी हमने ऊपर समझा था. See, similar questions do repeat. तो यहाँ पे आप वही section 84 discuss कर रहे हो that when a check is not presented for the payment within a reasonable time of the issue and the drawer suffers the actual damage due to delay because of the failure of the bank, he is discharged to the extent of the damage. Okay. तो अगर बैंक की तरफ से डिले है तो he is discharged to the extent of the damages. Okay, so if at any time the bank fails, the drawer has full amount of check within the banker for the payment of the check, he will be discharged in the full. Okay, so देखो अपने पास बैंक में पूरा पैसा है, लेकिन अगर बैंक अपनी ड्यूटी में फेल करता है, the drawer is not made liable and the relationship before the relationship is spoiled, you have to present the check. So in knowing what is a reasonable time with regard shall be paid to the nature of the instrument issued for the trade and the banker and the facts of the particular case. So what is a reasonable time? देखो RBI ने तो अभी 3 months बोल दिया. Otherwise, the reasonable time will depend upon the nature of the business and it will depend upon the trades that is executed. Thus, by using the above provisions to the given problems, as the payee has not presented the check to the drawer's bank within a reasonable time, when the drawer has funds to clear the check. The drawer has suffered actual damage. Yes, he has. And then the drawer is discharged from the liability also. Because bank अब काम नहीं कर रहा, bank has turned out, so who is actual sufferer? The drawer of the check. As a result, since B has not presented the check on time, when he has funds to clear the check, A stands discharged. B cannot demand from B. So it's very important that you present the check within a reasonable time and appropriately. Okay. Next one, Ram has 2000 in his bank account and he has no authority to overdraw. Okay, he issued a check of 5000 to Gopal, which was dishonored by the bank. Point out whether Gopal must necessarily give a notice of dishonor. Okay, so this is section 98 coming into picture. 98 prescribe the cases in which no notice of dishonor is necessary. तो क्वेश्चन से ये समझ में आया 2000 इन बैंक अकाउंट विच ही हैज नो अथॉरिटी टू ओवरड्रॉ की अथॉरिटी थी नहीं, तो यहां पर उसने 2000 होते हुए भी ज्यादा का चेक बना दिया. तो इतने ज्यादा का चेक बनाने की क्या जरूरत थी? 10. तो यहां पे सेक्शन 98 दिस इंक्लूड्स एंड ऑल्सो स्टेट्स that when a drawer has no sufficient balance and issue a check of excess amount and also not has the authority to overdraw, if the check was dishonored by the bank, then the notice is not required to be given for the drawer. Interesting. 98 has a different kind of nature. So when the drawer, it says when the drawer has no sufficient balance, okay, clear, and also has authority, no authority to overdraw, and if the check is dishonored by the bank because of this reason, interestingly, even the notice of dishonor is not required. So in the present case, no notice is required according to section 98. Okay, but yet I would say if a check is bounced under section 138, preferably give a notice because there is a non-obstante clause. Okay, preferably give a notice. Then यहाँ पर 10th question क्या बोलता है? S by inducing T obtains bills of exchange from him fraudulently in favor of S. Later, he enters into the commercial deal and endorses the bill to you towards consideration to him. You takes the bill as a holder in due course. You subsequently endorses the bill to S for the valuable consideration to S for some other deal. On maturity, the bill is dishonored and S to T for the recovery. With reference, will it be recovery? Interesting question. यहाँ पे S ने T से बिल लिया है, rather T से S ने बिल लिया है, but that bill is obtained fraudulently. वो बिल उसने U को दिया, U ने दूसरे ट्रांजैक्शन में वो बिल इसको एंडोर्स किया, ये इसने एंडोर्स किया, और S अब T के ऊपर केस कर रहा है, तो will he be recovering the amount? Absolutely no. Okay, but let's see how we can interpret. Section 53. Once a negotiable instrument passes through the hands of the holder in due course, it gets cleared of the defects provided the holder himself was not a party to the fraud. Okay, that's very important. Or the illegality which affected the instrument in the stage of the journey. So ये भी एक सेक्शन है, इंटरेस्टिंग पॉइंट है कि अगर होल्डर इन ड्यू कोर्स के हाथ से गुजरा है और होल्डर वाज नॉट अ पार्टी टू द फ्रॉड, इट कैन कम बैक. ओके, इट कैन कम बैक एज अ गुड इंस्ट्रूमेंट. Thus, the defect in the title to the transferor was not affected in the rights of the holder in due course, even if he had the knowledge of the prior defect, provided he himself was not a party to the fraud. तो अगर holder in due course, जैसे अपने केस में holder in due course is you and you was never a party, even if he has a knowledge के सामने वाले के पास title नहीं है, but yet he was never a party. Thus, applying the above provisions, S who originally induced T in obtaining the bills of exchange in the question fraudulently cannot succeed the case. Why? Well, ऊपर आपने लिखा है because S is not the holder in due course. The reason is obvious. S himself was a party to the fraud. S is not the holder in due course without being a party to the fraud. Okay, he was a party to the fraud. हाँ, you recover करता तो things would have been different. फिर हम title वाला question उठाते. बट यहाँ पे टाइटल का क्वेश्चन ही नहीं था, यहाँ पे क्वेश्चन ये था जो रिकवरी कर रहा है वो खुद पार्टी टू द फ्रॉड है कि नहीं, और अपना आंसर है यस, ही इज हिमसेल्फ अ पार्टी टू द फ्रॉड. Let's see the 11th one. Okay, यहाँ पे P a major and Q a minor executed a promissory note in favor of R. Okay, P is major and Q is minor, और इन दोनों ने मिलके promissory note in favor of R. Okay, you have to examine as per Negotiable Instrument Act the validity of the promissory note, whether it is binding on P and Q. तो यहाँ पे हम लोग क्या एनालाइज कर रहे हैं? यहाँ पे हम लोग एनालाइज करें एक मेजर और एक माइनर और उसके को रिलेशन में कैसे इंप्लीमेंटेशन. लेट्स सी दैट. सी एवरी पर्सन हु इज कॉम्पिटेंट टू एंटर इनटू कॉन्ट्रैक्ट has the right to incur the liability by making, drawing, endorsing, accepting, delivering, and negotiating the negotiable instrument. Simple. So only a person who is competent to enter into contract can actually enter into contract. Okay, can actually execute a contract. The agreement between the minor is a void one, and so he cannot bind himself by becoming a party to a negotiable instrument. Even a minor who is a party to the negotiable instrument cannot bind himself for that. But the instrument can be drawn or endorsed to bind all other parties. That's correct. So in the present case, P is a major and Q is a minor executed a promissory note in favor of R. The promissory note executed by P is a valid one even though minor is a party to it. Why? Because P तो major है, तो joint promisor होने के नाते P से recovery हो सकती है. Q being a minor is not liable, but his immunity from liability does not absolve other joint promisor that from his liability. That's true. See, Q being a minor cannot be made liable. But as far as the liability of another joint promisor is concerned, and here the P is a joint promisor, his liability cannot be absolved or cannot be done away. Clear? Then question number 12. Let's see. Mr. A is a payee of order check. Mr. B steals the check and he forges A's signature. Oh, and endorses the check in his own favor. Wow, अपने खुद के नाम पे ले लिया. B then further endorses the check to C, who takes the check in good faith and for a valuable consideration. What is the validity of the check, and also state whether C can claim the privilege of holder in due course. It's simple. Forgery gives no title. Okay, a forged negotiable instrument is a nullity. Forgery gives no title. Yes. So forgery confers no title. See, it's there. It speaks for itself. The holder of a forged instrument acquires no title. Thus, in case of a forged endorsement, the person who is claiming under the forged endorsement, even if he is not the holder in due course, or even if he is the holder in due course, cannot acquire the title in the holder in due course also. You cannot make a forged instrument legal just by giving it to the holder in due course. जो illegality से start हुआ है, वो legality पे कैसे खत्म होगा? क्योंकि वो starting से illegal है. Thus, C acquires no title on the check. Okay, so forgery gives no title. इस चीज का ध्यान रखना. Okay, this same June 16 का था. Question number 13. Mr. Bean is a promoter who has taken a loan on behalf of the company. But he is neither a director nor a person in charge of the company. He sends a check from the company's account to discharge his legal liability. Subsequently, the check was dishonored and a complaint was lodged against him. Can he be held liable for the offense of 138? Interesting. He is a promoter but never a director or the person in charge of the company, and he is sending a check on behalf of the company. Can he be made liable? Okay, let's see an answer to this one now. Let's write it up. The check is said to be bounced or dishonored for the non-payment when the drawee of the check makes a default in payment upon being duly required to pay the same. So जिसको जो पैसा देना था, the person who has to make the payment to the check, and if he makes the payment but the check is dishonored for non-payment, dishonored or bounced, a drawer of a dishonored check shall be deemed to have committed an offense and shall, without prejudice to the other provisions of the negotiable, be punishable. So one who draws the check is deemed to have committed the offense of check, and consequently the other party can be made liable for that. Clear? यहाँ पे देखो liability कितनी है? Imprisonment for a term of 2 years. जिसने वो check sign किया है, and the one who has to pay it in a debt as a liability, the imprisonment can be for 2 years. or with fine which may extend to twice the amount of check, or with both. So that is other than the check value. So the case is similar to that of HNB Mullah Force versus CY Samya Julu. It was held by Andhra Pradesh High Court that although the petitioner has legal ability to refund the amount to the appellant, the petitioner is not the drawer of the check, which was dishonored, and the check was also not drawn on account maintained by him, but was drawn on an account maintained by the company. Interesting. जिसने वो चेक साइन किया है फॉरेन ऑन बिहाफ ऑफ द कंपनी, वो लोन के हिसाब से, वो उस कंपनी का ऑथराइज सिग्नेटरी है ही नहीं. ओके, एंड द चेक इज नॉट ड्रॉन इन हिज पर्सनल नेम, इट इज ड्रॉन इन द नेम ऑफ अ कंपनी, और वो कंपनी का वो सिग्नेटरी नहीं है, and the account is actually maintained in the name of company, not that person personally. Hence, Mr. Bean did not be said to have committed offense under 138, and therefore Bean is not liable. तो अगर आपको केस लेना है तो कंपनी के खिलाफ केस लेना चाहिए कि how can you authorize a person to sign a check without proper authority? Okay, so that's where it could be a cheating, or it could be a case of you can say criminal breach of trust, but यहाँ पे negotiable instrument में तो नहीं आएगा. Okay, so that's where one has to be very careful when you accept the check. See that the person who is signing the check has the authority to sign the check or not, especially in the name of the company. Okay, इस चीज का ध्यान बहुत रखना पड़ता है when you see the checks. Now let's see the other one. अब next वाला देखते हैं, 14th one. Discuss with reason the following conditions: whether M can be called as a holder. Let's say M, the payee of a check, who is prohibited by the court order from receiving the amount of check. Is he a holder? And M is an agent of Q, is entrusted with the instrument without endorsement by Q, who is a payee. Is he a holder? So interesting. What is the holder of the instrument? See, when you say a holder, means a person who is entitled to receive the payment of the instrument. If he is not able to receive the payment, he is not the holder. You can say he is just holding the check or holding the instrument, but not a holder as such. He is not entitled to the payment of the check. So यहाँ पे first case में you are writing down M is not a holder. Court ordered M is prohibited from receiving the amount of the check. So he cannot be called as a holder of a check because he is not entitled to receive the payment on the check. And Q is a payee. Since Q is bound by the Agents Act, done any way with the permission or without, thus Q is bound to pay. So यहाँ पे Q is a payee and M is the agent. M the agent of Q. So Q के कहने के हिसाब से उसने आगे दिया है. So M is the agent of Q and entrusted with the instrument of endorsement by Q. तो Q ने दिया है, तो उसके हिसाब से M आगे देता है. तो जो उसका पेई है Q है, Q का नाम लिखा हुआ है चेक पे, तो Q is bound by the Agents Act. अगर M ने किसी को आगे दिया तो Q is principal is bound by the act of the agent, and therefore Q is bound to pay. Okay, समझा? So law of agency के हिसाब से Q is bound to pay, लेकिन M in the first case is not the holder. Okay, clear? अब इस next वाले केस को देखते हैं. यहाँ पे question number 15. F by inducing G obtains the bills of exchange from him fraudulently in his, that is F's favor. Later he enters into a commercial deal with H and endorses the bill to him, that is H, towards the consideration for the deal. Okay, so F by inducing G, he has obtained a bill, F has got a bill, and now he is endorsing it to H. Okay, H takes the bill as a holder in due course. H subsequently endorses the bill to F. Oh, so G say F, F say H, H say F वापस for the valuable consideration. F for some other deal. On the maturity of the bill is a consideration to F for some other deal. On maturity, the bill is dishonored and F sues G for recovery. Will F be succeeding? सर ऐसा वाला तो हमने पहले भी देखा है ना केस. Yes, काफी हद तक कभी-कभी केसेस रिपीट भी हो जाते हैं. Okay, so again section 53 coming into picture. यहाँ पे आप लिख रहे हैं section 53 provides once a negotiable instrument passes through the hands of the holder, in the due course. It gets cleared of the defects provided the holder was himself not a party to the fraud or illegality. हमने पढ़ा है ना पहले. Which affected the instrument in some stage of the journey. ओके इसलिए मैं सजेस्ट करता हूँ सारे केसेस अच्छे से पढ़ के जाओ कि कई बार एग्जाम में रिपीट हो जाते हैं और रिपीट होते हैं तो यू क्लिक अरे हाँ मैंने पढ़ा हुआ था. ओके so thus any defect in the title to the transferor will not affect the rights of the holder in due course even if he had the knowledge of the prior defect provided he himself is not the party to the fraud. तो उसने खुद ने गलती नहीं की होनी चाहिए. अगर he himself is the party to the fraud so then he cannot recover. Thus applying the provision above, it is quite clear that F, who originally induced B in obtaining the bills of exchange in question fraudulently, cannot succeed because obvious he himself is a party to the fraud. Same answer लिख रहे हैं हम लोग. ठीक है, clear? And 16th one, Q draws the bills of exchange on S but signs in the fictitious name as R. Oh, fictitious instrument coming into picture. So Q draws the bills of exchange but signs in the fictitious name of R and the bill is payable to the order of R. कि R के कहने पे. Okay. The bill is duly accepted by S. P obtains the bill from Q, thus becoming the holder in due course. Can S avoid the payment? Well, can the drawee avoid the payment? That's quite interesting. माना ये बिल फिक्टिशियस नेम पे था लेकिन R knows, R को तो पता था ना ये बिल किसने साइन किया है. So as a drawee, he cannot avoid the payment. Okay, but yes, the drawer could not have recovered. तो देखो ऐसे था, Q था, Q ने एक बिल S पे बनाया, Q ने एक बिल S पे ड्रॉ किया, लेकिन बिल पे R करके साइन किया है, R करके फिक्टिशियस साइन है. फिर Q ने वो बिल आगे P को दिया, P अब S से रिकवरी करना चाहता है. तो क्या वो रिकवरी कर सकता है? The answer, ऐसे हमने स्टडीज के टाइम पे भी देखा हुआ है. The answer is quite very obvious, yes, because fictitious bill पे S remains liable. He remains liable क्योंकि इसने तो अपनी तरफ से सही सिग्नेचर किया है, being the drawee. Okay, so as per section 42 of bills of exchange is drawn in the fictitious name and is payable to his order. The acceptor cannot be relieved from his liability. Yes, the acceptor cannot be relieved to the holder in due course. And the holder in due course can claim the instrument was endorsed by the same hand as the drawer's signature. तो ये तो बात सही है ना कि ड्रॉई ने अपना सिग्नेचर बराबर ड्रॉवर ने नहीं किया लेकिन ड्रॉई ने तो किया है. So in this case the Q draws the bill on S but signs it in the fictitious name of R. ठीक है, the bill is duly accepted by S. S ने तो अपना सिग्नेचर बराबर किया, उसको मालूम था ये कौन दे रहा है. So P obtains the bill from Q, becoming a holder in due course. Thus, as per section 42, S cannot avoid the payment of the bill. He is liable. Okay, he is liable. And question number 17 देखिए. So 17 says, A draws a bill on B and B accepts the bill to C. Okay, A draws and B accepts the bill payable to C on order. C endorses the bill to D and D to E, who is a holder in due course, and decide from whom E can recover the amount. Okay. So यहाँ पे बहुत सिंपल सा क्वेश्चन है. A ने B पे बिल बनाया, ओके, B एक्सेप्ट्स द बिल, फिर A ने वो बिल C को दिया, C ने वो बिल D को दिया, D ने वो बिल E को दिया. Is he a holder in due course? Can he recover from B, A, C, D? Okay, that's how it is. Okay, so let's see and understand this one. Okay, तो इसको समझते हैं. As per section हम लिख रहे हैं, as per section 36. Every prior party to a negotiable instrument is liable to holder in due course. That's true. Every prior party is liable to the holder in due course until the instrument is duly satisfied. जब तक पूरा पेमेंट ना हो जाए, बराबर. The holder in due course E, the holder in due course E can hold all the prior parties liable jointly and severally. मैं वही आपको समझा रहा था that E can be making liable B, A, C, D सबको. Okay, so he can make all the parties liable jointly. Prior parties include the maker or the drawer, the acceptor, and the endorsers. So who are the prior parties? The one who makes or the drawer of the instrument, and further the acceptor or endorser. So accordingly, in the given problem, E is a holder in due course, can recover the amount from all the prior parties, that is D, C, the endorsers, B, the acceptors, and A, the drawer. That's it. That's what itna hi samjhana tha. Okay. And let's see the 18th one. 18th one, December 19 के पेपर में आया था. X draws a check in favor of Y, a minor, and Y endorses the same in favor of Z. The check is dishonored by bank on the grounds of inadequate funds. What legal remedy is available to Z under the provisions of negotiable? Simple. Minor के favor में check था और dishonor हुआ. Let's see. See यहाँ पे the capacity to incur a liability as a party to the negotiable instrument is coextensive with the capacity to the contract. So as good as a person who is competent to contract is also a person who can sign a negotiable instrument or enter into as a party to the negotiable instrument. If you cannot sign a contract, you cannot be a party to the negotiable instrument or liable party as such. Okay? So section 26 क्या बोलते हैं? According to section 26, every person capable of contracting according to the law to which he is subject may bind himself be bound by making, drawing, acceptance, endorsement, delivery, negotiation of promissory note, bills of exchange or check. So जो भी person capable of contract है, that person can only actually execute or actually enter into a contract or actually enter into the negotiable of a contract or any kind of acceptance, endorsement, delivery of a promissory note, bills of exchange or check. So negatively, minors, lunatics, idiots, drunken, person disqualified by personal law, they do not incur any liability as a parties to the negotiable instrument. It's simple. So, but the incapacity of one or more parties to the negotiable instrument in no way diminishes the liability of the competent parties to the said instrument. ये हमने पहले भी देखा. In a joint owner also, if one party is a minor and the other party is a joint owner, so the liability of the competent party always remains. Therefore, when a minor is the endorser or a payee of the instrument, which has been endorsed, all the parties excepting the minor are liable to the event of the dishonor. तो माइनर को छोड़ के बाकी सारे पार्टी जिसके अगेंस्ट लाइबिलिटी वो तो अराइज होगी. तो एक्स ड्रॉज अ चेक इन फेवर ऑफ वाई. वाई इज अ माइनर, ही इज अ पेई, ही इज अ माइनर. एक्स तो माइनर नहीं है. तो Z can recover the amount of check from X who delivers the check in favor of Y, a minor, by resorting to the provisions of Negotiable Instrument Act. Okay, so आपने एनालिटिकली देखा ये सारे क्वेश्चंस एंड होपफुली अगर आप एग्जाम में इतने सारे क्वेश्चंस देख के जा रहे हो, आई एक्सपेक्ट कि आप एग्जाम के केसेस विच इज नियरली ऑफ 20 मार्क्स और समटाइम्स 25 मार्क्स आप उसको आराम से हैंडल कर सकते हो. ओके, तो यहाँ पे वी हैव सीन क्वाइट अ गुड नंबर ऑफ केसेस एंड यस कॉम्पिटिशन एक्ट के भी केसेस देखे. सो होप दिस टाइम कॉम्पिटिशन एक्ट के अंदर और भी ज्यादा अगर केसेस आएंगे तो यू कैन बी टैकलिंग दैट. सो ओवरऑल यू हैव सीन लॉट. Okay, so all the best, all the best, all the best for forthcoming examinations. Do it well and we will meet again in some other form. Okay, goodbye and best of luck. Bye bye.